send you another text message for the trademark session. And before the panel comes in, let me briefly introduce who will be on the bench. For trademark moot court, Judge Takafumi KOKUBU of IP High Court of Japan, again in the order of their sitting on the bench. Judge Hong Liu of Guangzhou IP Court of China. Judge William ALSUP of U.S. District Court for the Northern District of California. Judge Oliver SCHÖN of District Court Munich of Germany. And Presiding Judge Sungsik of the Patent Court of Korea will serve as a panel. Judge William also will be the presiding judge. As plaintiff's counsel, we have Mr. Kijoong, Mr. Kim, Mr. Kiyoon LEE, attorneys, and Ms. Susan Park, U.S. licensed attorney from Kiyoon LEE. As defendant's counsels, we have Ms. Seol, Mr. Seung, attorneys, and Ms. Kim, U.S. licensed attorney from Munich. Last but not least, High Court Judge Soonmin and High Court Judge Yoon served as the organizing committee members for the trademark session. We will begin once the arbitration panel enters the room.
대리인들 죄송한데 정말 스케줄이 많이 지연돼가지고 45분까지 판결이 선고가 돼야 되거든요. 자.
All rise, please.
Please be seated.
Welcome, everyone. We're here for the trademark case. Panel of 5 judges. And because time has been misappropriated on the patent case, time is precious. We will not have any introduction as we did in the last. We're going to go, because of the excellence of these lawyers, they're going to do their arguments in less time than before. Each side gets 9 minutes total, 1 minute for rebuttal, plus a few questions maybe by the judges. So 9 minutes, please be aware of that. All right, so the case is CrossFit Inc. Versus Cal Sports. This is a trademark case, or is someone ready for the plaintiff?
Good afternoon, Your Honor.
Please introduce those on your side, and then you may begin, and we will start timing. Thank you.
Thank you. My name is Susan Park, and I'm here with my co-counsel, Kijoong, Kim, and Kiyoon LEE, and we represent the plaintiff.
Please go ahead.
So the plaintiff in this case is CrossFit Inc., the owner of the registered Korean trademark CrossFit as shown on the screen. Plaintiff licenses CrossFit mark worldwide to fitness clubs and gyms and has over 200 licensees in Korea alone. The defendant's CA Sports Inc. operates a gym and uses this mark, which shows at the bottom of the screen, and which contains plaintiff's registered CrossFit mark as the name of its business, but defendant has no license from the plaintiff for its use of the CrossFit mark. The issue in this case is about whether defendant's unauthorized use of the mark CrossFit constitutes infringement of plaintiff's registered mark. And more specifically, the issue is whether defendant's mark is similar to plaintiff's registered mark, where both parties are using their respective marks in connection with the business of physical fitness. And the plaintiff's position is that such use is an infringement of its registered mark because the two marks are similar when compared based on the prominent part of the defendant's mark, which in this case is the word CrossFit. It is the plaintiff's position that the other components or elements of the defendant's mark lacks distinctiveness and thus should not be afforded trademark protection. What we are dealing with is a composite mark, and composite mark is comprised of words and designs, as is the case in the defendant's mark here. In determining whether the composite mark is similar or not, the Korean Supreme Court has taken into consideration of various factors. Namely, the court looked at the prominent, what constitutes the prominent part of the mark, and what's particularly notable in the court's decision is that it's not the mere size of the word that counts in determining the prominence, but it's the distinctiveness of that mark. And other factors considered by the court is the well-known or the famous status of the prominent part and its distinctiveness in comparison to the rest of the components of the mark, and how the goods are traded, how the goods are perceived as a source of indicator in the industry. And we come back to the defendant's mark, and when we apply the prominent part test, the plaintiff's position is that only the CrossFit part of the defendant's mark is prominent, and thus that should be considered when determining the similarity to the plaintiff's registered mark. The CrossFit part of the defendant's mark has its independent distinctiveness as a source indicator for plaintiff's business. The sheer fact that there are over 200 CrossFit branded gyms in Korea licensed by plaintiff is clear evidence that the CrossFit part of the defendant's mark is being independently used in gym business. And CrossFit part maintains its distinctiveness as a source indicator and thus is not a common name or a commonly used mark or a descriptive mark, and thus should be afforded trademark protection. When looked at in more detail, the defendant's mark has various components. The letter, although it says CA Sports, CA is a two-letter word, and according to the Korean trademark prosecution practice, two-letter words are not distinctive enough to be warranted, to be granted trademark registration. So it would be deemed indistinctive. The word sports is a common term and thus lacks distinctiveness. And the logo is also rather indistinctive in sports business. So the plaintiff's position again is that the word CrossFit, which looks exactly the same as the plaintiff's registered trademark on the left, is the only distinctive aspect of the defendant's mark. The next issue is whether plaintiff's CrossFit mark has lost its distinctiveness such that it has become a common name or a commonly used mark, or even worse, whether it has become a descriptive mark for which trademark protection should not be afforded. A common name or a commonly used mark effectively means a mark which is used to commonly refer to a particular designated goods or services rather than as a source indicator for such goods or services. As applied to the present case, the issue is whether CrossFit has come to be perceived as a common word used to refer to certain specific exercise program rather than as plaintiff's trademark or brand. And there is sufficient evidence to show that it has not. Unlike the defendant's argument that CrossFit is a mere combination of the word cross-training plus fitness based on the average English speaker standpoint in Korea, we do not think that an average consumer would perceive CrossFit to mean cross-training plus a fitness. The plaintiff also makes proactive efforts to protect its brand, to protect CrossFit as a brand, as indicated on posting on the Wikipedia, where it is described as a brand name created by its founder, and it includes the history and business model and the types of certification that's issued by the plaintiff, which all tend to establish that CrossFit is a brand name rather than a common name or a commonly used word to describe a particular exercise program. And also, the neighbor, which is the Korean equivalent to Google, clearly states that CrossFit is a brand name. Plaintiff provides a unique fitness program and support network for CrossFit-affiliated gyms. It only allows its authorized licensees to use the word in connection with the fitness business, and it aims to produce best results. And it has come to be perceived as a high level of quality service in the fitness industry, and that has become the consumer's expectation, the consumers who use such services. Since 1995, CrossFit has continuously used the mark CrossFit in commerce to designate its distinctive program. And CrossFit Inc. owns many trademark registrations worldwide, including Korea, and all of which indicate that the mark has not been rendered generic or has become a common name or commonly used word. Also, CrossFit is not used to describe any particular type of exercise. There's simply no evidence to support that the mark has become a descriptive mark to use its function as a source indicator for the plaintiff's brand.
We're at the 9-minute mark, so why don't you take one more minute, and then we'll turn to the defense.
That is basically it. The fact that CrossFit as a mark has been maintained as a distinctive mark of the plaintiff, and thus reported trademark protection, and defendant's unauthorized use of the mark constitutes infringement.
Thank you. Who's the defense right? Who will speak for the defense?
Thank you, Your Honor. I, GSR, and the Co-Counsel, Jeong and Soonmin. We are acting on behalf of the defendants, Kiyoon LEE, and I would like to present the defendant's argument for now.
Yes, sir.
Here's the fact of the case, but as we already screened the fact of the case through the plaintiff's argument, so please let me skip this page. Here's our legal law. Korean Trademark Law, Article 108, which ruled at things infringement, and Article 90, which ruled extent on which trademark rights do not have impact. Let's move to the issues and related legal principles. As we already know, the ultimate issue of this case is whether the plaintiffs are registered trademark and the trademark used by defendants are similar to one another. And this is the method of determining whether a trademark is similar to another. Overall, an objective observation of the trademark sight, sound, and meaning in comparison by imitation. And Korean Supreme Court holds the detailed criteria for the judgment of similarity. First, principle of overall observation. Second, not considering the part lacking distinctiveness. Third, observation of the prominent part as a supplementary measure. So first principle, overall observation. So even if there is a similar part between the contrasting trademarks, it is unlikely that the trademarks at issue will be considered as similar. First, when it is unlikely that the similar part will be perceived separately from the whole. Second, when it is clear that there will not be any confusion as to the source of the product when the trademark is understood in its entirety. So please see the cases. These cases share the similar part of each other. So this Jimmy and spoon, and project. But the court holds that these are not similar under the overall observation principle. And second principle, not considering the part lacking distinctiveness. So I will do the second decision. If any of the components of a trademark include parts of the designated product marked with the common name and the commonly used trademark or the descriptive mark, etc., such part may not be regarded as a prominent part of the trademark mentioned above because it is indistinguishable from other products. Thus, it would be appropriate to observe only the remaining part of the trademark other than such in determining similarity of trademarks. So here are also the cases. These cases also share the similar parts with electric, energize, digital, and kinder. As these similar parts are all lacking distinctiveness, so the court holds that these marks are not similar when observed in entirety. And third principle, observation of the prominent part as supplementary measure. So for a combined trademark like this CrossFit case, consisting of a combination of two or more letters or figures, in order to induce appropriate conclusion after overall observation, in an instance where the trademark has a prominent part, it is necessary to prepare and judge the similarity of the trademarks using the prominent part. And these cases also share the similar part. Moot's occurring in monster, the animal U, and KANG, and Soonmin. Yes, but those parts cannot be the prominent parts of the trademarks. So the court holds that these are not similar under the overall observation, except the number 3 case. So now we move to apply these principles, legal principles to this case. And please remember the second principle, no considering the parts lacking distinctiveness. And the trustee part of the defendant's mark does not have distinctiveness. Because first, CrossFit is a common name or commonly used trademark. As we already see the concept of the common name and the commonly used trademarks, so let's just see the standard of the determination. So please note that the standard for the common name is a perception of ordinary consumers, but the standard for the commonly used trademark is the perception of individuals engaged in similar businesses. Is logic, and our Supreme Court holds that although a registered trademark may at the time of registration already have been considered a common name, and there could have been instances where it became a common name despite sufficient trademark management. And the Supreme Court also holds that the foundation for cosmetic, and G for car, and Vaseline for cream for medical use, and Rasandra or Cardinal for roses, and Obukte for pickled vegetable already became a common name or the commonly used trademark. And let's see the case. According to the Neighbors Dictionary, CrossFit is defined as a compound word, which is a combination of cross-training and fitness. And despite explanation of Neighbors Dictionary, having been partly revised and request of Plaintiff, it also states that it refers to an exercise that is done during a short time in high intensity by mixing several kinds of exercise. And now it is commonly used to refer to a method of working out alternating between the different type of exercise. And according to Wikipedia, CrossFit is defined as a rugged fitness regime. And we also have to consider the actual use of CrossFit. And the thing is that there is no alternative available if CrossFit is prohibited from use. Second, CrossFit is a descriptive mark, which is a mark indicating a method of common use of processing, a method of use and time. And here is the logic and also the factors of consideration of determining descriptive mark. And this is the cases regarding descriptive mark, PC direct, and hotmail, and hyung. So when we consider the factors regarding crossfit at the slide before, the crossfit should be the descriptive mark that describe the contents and type of exercise provided by the defendant. And we believe crossfit cannot be a prominent part of the defendant's mark. As you already know, a prominent part of a trademark refers to a part that performs the function of indicating source of the product independently by its product by giving the impression of memorizing and associating the trademark to the general consumer. And these are the factors to consideration of determining the prominent part. Please see this. And let's see the case. The crossfit part of the defendant's mark does not possess the distinctive power because it is a common name or common use trademark or descriptive mark, as we see before. Perhaps, even if this is not the case, its distinctive power is still relatively low considered to other parts of the defendant's mark because a considerable number of consumers recognize CrossFit as a name of a specific type of workout method. And there is a very low possibility that consumers having access to the defendant's mark will separately recognize the CrossFit part because the part is located at the bottom of the whole mark in a much smaller size than SCHÖN, which is written in a very large size at the left top of the whole mark. And this is very high. There is a very high likelihood that the consumers having access to the defendant's mark will recognize the part SCHÖN and this drawing displayed largely at the top of the mark as a part performing the function of indicating the source of the product, while recognizing that CrossFit part displayed in a very small size is an explanation of type of workout provided by the defendant. So we do believe the CrossFit part does not perform the function of indicating the source of the product, and Plaintiff's argument that CrossFit is a prominent part of the defendant's mark does not hold.
All right, thank you. Now, before we get to rebuttals, we are going to have questions from the judges first. I have a question. Yes, please.
Thank you, sir. First, I asked the plaintiff counsel, and the plaintiff argued the CAN sport of the CA sport combined are both non-distinctive, but taking into account that CA sport combined takes up a large portion in the whole base on the front side, and then CA sports is a coined word, not the rest of the word in the dictionary. Despite the non-distinctiveness of both CA and sport, the CA sport combined still lack distinctiveness. How would you respond to that?
Thank you, Your Honor. Just as you just said, merely combining two indistinctive terms would have made the word distinctive in its entirety. And as referenced in our presentation, the Supreme Court has clearly said that when looking at the prominent part of the mark, the mere size isn't the dispositive factor, and we must consider other factors such as the distinctiveness of the mark.
Thank you. Next, Defendant or Counsel. And plaintiff argued the CA sport of the defendant's mark lacks distinctiveness. Please make a countermand argument defendant.
Yes, first of all, we cannot agree with the plaintiff's argument that the CA sports part of the defendant's mark lacks distinctiveness. Meanwhile, we also want to emphasize that whether the CA sports part of the defendant's mark possesses the distinctiveness or not is not an important issue in this case. Rather, we believe that the main issue of this case is whether the CrossFit part is distinctive enough to constitute a prominent part. which to this we argue as previously explained that CrossFit constitutes a common name, commonly used trademark, and or a descriptive mark, which therefore lacks the distinctiveness required to constitute a common part. In such instance, we believe that it's important to return back to the basics and to conduct an overall observation of the mark at issue. After such overall observation, it will become clear that the sight, sound, and meaning of these two marks are all different, therefore leading to the conclusion that these marks are neither identical nor similar. Thank you.
All right, more questions? I have a practical question. Let's say a potential customer is walking down the street and sees your mark, see a sports, and then underneath it, it says CrossFit. Now, isn't there a risk that the ordinary potential consumer walking down the street and seeing that mark will see the word CrossFit under it and think that CA Sports is a licensee of Plaintiff? And therefore, if you go into the store and sign up, you're going to get their specific regimen of training. Don't you think that's a high risk here?
Well, there is a possibility, of course, but I believe that it is not easily happen because it is very, it needs much explanation to understand that kind of a situation. And CrossFit, in that situation also, CrossFit is not a distinctive. CrossFit itself also rather distinctive also, and people will see the C's performance, and that is the prominent part in this defense.
In addition, we believe that. In addition, we believe that the CrossFit mark itself, although it is worldwide licensed, most of the people, the prevailing audience and the ordinary consumers are not sure that the CrossFit itself is a licensed mark itself, and rather they believe that it is a way of alternating, a way of exercising, and which we believe would be actually helpful.
But didn't the Korea Trademark Office give a registered trademark called CrossFit to Plaintiff? Right? They have a registered trademark.
Yes, they do.
It says CrossFit. And so the trademark office must have thought they qualified, that word qualified as a trademark, right? Or am I missing it?
Well, yeah, they did a registration. They have a registration, but there can be they registered a trademark, but also we got a license, but they do not allow the use of the trademark itself. So then we have to use our own trademark. So that can be happening. So I mean that our trademark and our the prominent parts in our marks is C scores. So that is more acceptable.
Let me ask you something. That says that the word CrossFit is a generic term for a way to get in shape, cross training sort of thing. Therefore, CrossFit, and that you have misappropriated that term from the common lexicon and tried to monopolize the term and exclude other people from using it for commercial purposes. So isn't it true that the word CrossFit does a common meaning about this cross-training thing, rather than, even if it does also mean, it's also your trademark.
Thank you, Your Honor. We hope to have illustrated in our presentation that the word CrossFit, and at least as applied to the Korean consumer, that it does not describe, or it's not a term commonly used to mean cross-training fitness. And the Korean Intellectual Property Office took that into consideration in granting the exclusive right to the mark to the plaintiff. And the likelihood of confusion that, and the risk that you mentioned to defendant, that is precisely the standard that will be applied in determining whether there is infringement.
Is that the test? If the court determines that there is a likelihood of confusion of the consuming public, is that enough for you to win?
Also, we would like...
Well, what's the answer to that? Is that enough for you to prevail?
That's the legal standard. And in this case, plaintiff has been very proactive in protecting his mark as a brand. So the plaintiff's position is that the mark is still distinctive as a trademark.
Okay, again, I ask my colleagues, any questions? Yes, please.
May I ask the plaintiff?
Yes, please.
Thank you. Plaintiff explained the ground that the CrossFit is not and not general, and it's not very descriptive. I would like you to explain the ground with CrossFit. Yes, the prominent part, the prominent part of the defendant. Could you explain more?
It is a question why the word CrossFit,
Yes,
why is it the prominent part of defendant's mark?
That's right.
Because the other elements comprising the defendant's mark, namely the letter CA, sports, or the logo with the person holding a weight, each individually lacks distinctiveness, and CrossFit is plaintiff's registered mark, and just the fact that plaintiff licenses the mark to over 200 users in Korea, and that itself proves the fact that the relevant consumers in the industry has come to expect and identify the word CrossFit as a brand and not as a common name.
Other questions? But we have 1 minute per side for closing argument. And we'll start with the plaintiff. The plaintiff may go first.
Thank you, Your Honor. CrossFit is a distinctive registered mark of CrossFit Inc., which is recognized by Korean consumers as a brand of the plaintiff. There's no evidence to support that CrossFit has become a common name or a commonly used term describing a particular type of fitness training. And plaintiff has been very proactive in protecting the CrossFit mark as a source indicator for its brand. The defendant's use of the word CrossFit as part of its business name causes confusion to consumers and thus constitutes infringement of plaintiff's trademark right. And the defendant's argument that CrossFit has become a common name or a commonly used term lacks both legal and factual basis. Therefore, we ask the court to find for infringement and rule in plaintiff's favor.
Thank you. At this time, we will hear the closing argument of the defense.
Thank you, Your Honor. So this is our conclusion. Fitness part cannot be considered a prominent part of the defendant's mark because it already lasted its 10 years, and also its portion is relatively very small compared to the other parts. So it cannot be compared with the plaintiff's registered trademark. So the registered trademark shall be compared with the defendant's mark as a whole, or the defendant's mark excluding the prosecuting parts. So please see the registered trademark itself and the defendant's mark as a whole. So the comparison of the marks as a whole, or the contrast of the two mainly based on the portion that states CA's first on this drawing, clearly shows the discrepancy in the size and the meaning, which leads to the conclusion that those are not similar. So there is no infringement, so we believe that this should be dismissed. Thank you very much.
Thank you. The case will now be under submission. I'd like to thank the lawyers for shrinking their time and organizing themselves so well that you have. You've done a fantastic job on both sides. We thank you for that. We ourselves are going to have to shrink our time to decide this case in 5 minutes. We will be back in 5 minutes while you contemplate who should win. Thank you. All right, please be seated. We are in total unanimous agreement that the lawyers in this case are terrific. They have all done an excellent job. And we would be proud to have them represent us in any kind of proceeding. They are excellent. So good for both sides. Here is our decision. We are unanimous that CrossFit is not a generic mark or a commonly used mark, so the plaintiff wins on that point. We are unanimous that CrossFit is not a descriptive mark. Plaintiff wins on that issue. That is not enough so far. One more issue. That one more issue is the registered trademark and the defendant's mark, are they recognized as identical or similar? And here, the decision is 3-2 in favor of the plaintiff. So we decide that it is similar enough that there is a likelihood of confusion, and therefore, plaintiff's judgment will be entered for the plaintiffs. However, because this is such a close case, your chances on appeal are very good. And again, we congratulate both sides. We were told that we needed to be done by 4:45, and we made it within 3 minutes. The organizers want us to stop now or to have more questions or comments? Have you even done this computerized thing yet to see how the audience came out?
Sure.
Has that been done?
Yes.
Yeah, tell us what that result was. So, what is that? The plaintiff wins in the audience?
Yes.
Okay. All right, there you go. What shall we do next?
Well, if you're all for the great work for the panel, the counsels, and the jury, the court and the panel thank for the jury service. Now, I hope the both sessions gave you some thought-provoking experience, and it's such a rare opportunity to see all the judges from different countries on the same IP bench. I'm sure we could go on if you had all day, but we should really wrap up, and we have reached the end of the program of the entire conference. We will conclude with the closing remarks from Chief Presiding Judge Hyun Kim of the Patent Court of Korea. Please give her a warm round of applause.
Good afternoon. I'm very pleased and relieved that the conference was finished successfully. I'd like to thank all of you very much for coming all the way to Daejeon and sharing a lot of valuable knowledges and experiences with us. And I would also like to thank judges and staff here in Daejeon. We have put huge efforts into preparing this conference. I would wonder, some of you play musical instruments or compose music. I've always admired musicians because of the novelty or at least the inventive step of their works. I think the human has been evolved to feel happy while they are making something new. And another reason why I envy musicians is that they make people happy without hurting any other feelings. Unfortunately, as a judge, I've never seen any case where one party is as satisfied as the other party. And in fact, I'm not really sure what is the key to happiness. Is it a joy or comfort? I don't know. But one thing I can tell you is that happiness is a mental or emotional state of satisfaction after devoting your efforts to something meaningful, something beneficial for people around you. As you know, the panels of this conference have been kind enough to answer so many questions asked before the conference. Thanks to them, you have been able to prepare each session of the conference until the last minute. As such, as our efforts to set higher standards in IP litigation are intended to advance technology and make our life better through it. And the other thing I can clearly speak about happiness is that happiness becomes real when shared. All the achievements of this conference are not made just by one panel, but by all the panels and participants here. So I'm happy now because I'm here sharing this experience with you. And I hope you feel the same and this conference will remain long in your memory. For guests from abroad, you are given the Korean traditional stamp with your name engraved as a souvenir. The design on the stamp is called sonde in Korean. It's the shape of the picture on the screen. Before modern times, people used to live in small villages. This is a sculpture embodying the shape of birds such as wild duck or wild goose on top of a tree. Wild ducks and wild geese are migratory birds. They come to Korea Peninsula in late fall looking for shelter, and they fly away to north when spring comes. So sonde is built to wish for good luck and success when a person leaves home, or to celebrate the success and safe return when he or she comes back. Like the bird on the tree, I wish you all good luck and success, and I hope we have another happy time at the IP Court conference here in Daejeon. Thank you.
Thank you very much for the great remarks. It was definitely a message that we can all agree and appreciate. Now, ladies and gentlemen, we have officially reached the end of this year's program, except for the trademark session judges and counsels for the Polish layer. And I really hope that the conference gave you some fond memories. Thank you for joining us this year. Have a great evening.
잘했어. 하나, 둘. 원, 투. 네.